excuse me, I have a broken tooth. If we need it, it's in my front pocket. So I will be lisping today, and I will attempt to enunciate, and I will attempt not to smile, because it would frighten you if I smiled at this point in time. Took a shot at leaving the temporary tooth ends. It is in my front pocket. Now, if I can give this presentation under those extreme exigent circumstances, surely you will be able to give your arguments in front of your TA this week sometime. As you know, hopefully at least 60% of you, more than half, we're shooting for more than half, will get a dispositive motion done, drafted, completed today, tomorrow, this week, and get them turned in. My class, my two sections, I think you owe me a summary judgment motion by 5 o'clock tonight. I suspect some of the classes won't have to get yours in until later this week, but at some point you have to get those dispositive motions in. What happens after you turn in a dispositive motion? Once you file one with a court, with a trial judge? Well, remember what we're trying to accomplish. We have filed, F is a difficult word. We have filed the summary judgment. We now need a ruling from the court. If you are in the Western District of Missouri, United States District Court for the Western District, what will happen is the judge will rule on your written motions without oral argument unless you ask for oral argument. The judge will rule without asking for oral argument, so you have to ask. If you were in the United States District Court for the Eastern District, works just the opposite. In the Eastern District, you ask, the judge isn't going to rule until you do oral argument. But the point is, whether you're in the Western District, Eastern District, you are allowed to at least ask to argue your motion in front of the judge. Well, let's assume that that is what is going to happen. You filed your motion, it is now time to argue it. Now, understand what you're trying to accomplish. For Professor McGar's section and Professor Scott's section, we're trying to convince a judge that notwithstanding the fact that we had a really mean dog that ate an ear, and knocked a poor meter reader down, and just ripped the holy socks off of this woman, took her ear and ate it, and then vomited up and ate the ear a second time. This was a bad dog. And we are trying to convince the judge to let us go home, and as if the dog had never attacked anybody. The dog even attacked a poor little boy who was selling eggs, going house to house, selling eggs. That's one way to characterize what the vandal on the bicycle was doing with the eggs at Halloween. It's my understanding that the other sections have a similar sympathetic defendant. You've got a really vindictive person who is just saying vile things about another fellow professional, and you are again asking the judge to grant summary judgment, or it may be a motion to dismiss. I don't know exactly what you're doing. Probably a summary judgment in your favor, so that your client can go home as well. That's what we're trying to accomplish. How do we do it? Well, you've got a handout here, and once I tell you that everything that I know is in this handout, many of you are going to start heading for the exit. Mr. Henderson, got it blocked? Good. Nice job. Gentlemen, come on down here. Let's give them a demonstration. Can I get 2 random volunteers? You two up front might be good. Here's where you can stand over here. I'm going to go through the handout, and we'll talk about the different parts of arguing a motion. And as we go through, I'll turn to these random volunteers and ask them to give us a demo. Now, you've decided you're going to argue your motion in front of a judge. What rule, is it going to be in chambers or is it going to be in court? I don't know. How do you find out whether it's going to be formal, you're going to come to court, you're going to stand behind a podium, there will be a court reporter there, or whether or not the judge is going to say, gentlemen, come on back to my office, let's talk about this summary judgment. It could be either way. How do you find out? Call the court. Most of the judges have clerks. That's a good way to do it. You can either talk to someone else in your office who has argued a motion in front of this particular court, or call the court and ask to talk to the court clerk. Say, hey, I've never been in front of this judge. What is the judge? What is the procedure? But it could be either way. You could be sitting casually inside the judge's office. This week, you are going to have to argue your motion for summary judgment. And the good news on your summary judgment, Nick, good news, no matter how pitifully bad it is, your TA is going to grant it. They're going to grant you. Yeah. You could write your name and the word please. They will grant it. Because if we don't grant your motion for summary judgment, we can't fire you and put you to work on the other side so that you can take the appeal from the granting of the summary judgment. Okay? So no matter how bad it is, you will win this summary judgment. All you got to do is show up and say your name and please. Be like that little kid in that, what a Great Expectation. Or please, that's all you have to do, and you will win this one. If you want to do a little bit better than that, however, let's follow these tips. First thing you're going to do when you begin your argument is you greet the judge. You greet the court.
Howdy, Judge.
Either one works just fine, depending on whether you happen to know the judge or not, and whether you're from Texas. There are two ways to do a greeting. Mr. Risberg did the formal greeting. It's what we traditionally think of. May it please the court. There's never a time when that is not appropriate. There's never a time. But depending on whether you are back in chambers, whether you're out in the courtroom, an informal greeting might be just fine. Okay, you've said hello. Now tell the judge why you are there. No magic words. Basically, you're saying, hello, judge, and then reminding the judge what you're there to see her about. Why are you there? And you need to tell the judge this even if the judge told you to be here. That's why we're here. The judge has lots and lots of files in her office, in his office, so we need to tell the judge why we're there.
Your Honor, we're on the defendant's motion for summary judgment in the Shy versus Big Brothers case.
Your Honor, the
You tell him. Pretend there is the judge.
defendant has filed a motion for summary judgment in the case Shy versus Big Brothers. The plaintiff believes that motion should not be granted.
Excellent. Next thing we're going to do. So we greeted. We've told the judge why we are there. We're here to talk about a motion for summary judgment. Now's the time you need to give a little bit of background and you need to identify the key issue or issues. Remember, the judge is likely to have lots and lots of pending cases. Hundreds of pending cases. If you go down to Cole County, back when Judge Kinder ran a courtroom on law day, his most common word was next, next, next. There'd be 100 attorneys in the courtroom, and he'd be going next, next. Now, you don't think Judge Kinder's a bright fellow, but he doesn't know all 100 cases. He's told everyone to show up and be prepared to argue with something about their case. Maybe it's just to bring the judge up to speed on a status. But next.
Your Honor, this case is about an invasion of privacy. The plaintiff works at the Big Brother store, which is a discount store. It has surveillance cameras throughout its entire store, including the locker room and even the shower area within the locker room. Now, one day, some employees of Big Brothers decided it would be fun to take those secret surveillance camera pictures and take a picture, zoom in on the plaintiff, take a picture of his naked buttocks, exposing a tattoo, a rose, imposed on the shape of Texas, right there, and they displayed this photo in the employee break room. Every employee of the store could see it, and every customer who walked by the break room could also see it. There are two issues we're here to talk about today.
Now, by the way, before we go to the issues, the way Sam has laid out the facts, are you already leaning towards, anybody just a little bit of peeved yet? Anybody a little bit peeved? You see what he's done by laying out the facts the way he has. Everything that he said is true. I don't think Michael's going to disagree here in a second, even though Michael's on the other side of the case. But because of the way he's laid out the facts, without any spin, he simply, this is just what happened. And already we are leaning his way. I'm sorry to interrupt.
There are two issues today. The first, whether it was reasonable to have a surveillance camera in a shower area where there is an expectation of privacy. And two, whether enough people saw this photo to meet the publication requirement.
Mr. Risberg?
Your Honor, plaintiff has indeed asserted 2 invasion of privacy claims. However, it is undisputed that the cameras in Big Brother's discount store were used to curtail employee theft. Further, Big Brother's employees were told that they may be under camera surveillance at any time while on company property. And we agree that the 2 issues in this case are whether or not it was reasonable to install cameras in areas where employee theft was common, and whether enough customers saw the photo in the back of Big Brother's break room to be deemed disclosed to the general public.
All right. So we got some facts from the other side. Mr. Risberg told us business reason. These naked people were shoplifting left and right. There were naked people with tattoos, Judge, tattoos. Anyone with a tattoo, we know about tattoos. You're a tattoo person. What is it? What does that mean? What does it mean you got a tattoo? What does it mean? I wasn't arguing you, but that's okay. Cut him off. What does it mean if somebody has a tattoo? Thief? Oh, easy question. We're learning facts from the other side. I don't even know why we're going to even bother to hear the rest of the argument. So let's assume we want to go on and find out what the controlling rules are in the case. At this point, we need the controlling rules. So we said howdy. We told the judge why we're there. We gave a little bit of background. We identified what the issues are. Now, in order to resolve this thing, doesn't the judge need to know what rules do I need to apply? Counsel?
Your Honor, to show an invasion of privacy claim, you only have to meet 2 elements. 1, that there was secret and private information, and 2, the defendant learned about this secret and private information in an objectionable way.
Your Honor, plaintiff can't win under his publication theory unless he can demonstrate that private information was disclosed to the public at large or to a sizable amount of people so that the information would become public, so whether it was substantially certain to become public. Communication of one person or even a few is simply not enough.
All right. I want you to look ahead just for a second and look at miscellaneous point number 2. Defendants should consider conversing the rules or the elements. Should consider conversing the rules or the elements. That's exactly what just happened here. I don't know if you noticed it, but that's what happened. When Sam asserted the rule, as here for the plaintiff, he said, Your Honor, we win if. He said, all we have to do to win is, Judge, all we have to do to prove to win this case is show the first offer, acceptance, and consideration. That's all we have to do. That's called stating the rule in the affirmative. The plaintiff tends to want to spin it psychologically that way. Michael assumed the exact same rule as Sam did, but he converted. And he said, Your Honor, unfortunately for Sam, his side cannot win unless 1, 2, and 3. It's called conversion. They can't win unless they can prove offer, acceptance, and consideration. If you're on the defense side, you tend to want to converse rather than go affirmative. All right, next thing we need to do. We told the judge what the rules are. Now we need to apply the controlling rules to the facts of our case. Controlling rules to the facts of our case. Counsel?
Your Honor, of course, the plaintiff had a reasonable expectation of privacy in the showers in the locker room. Furthermore, even if the surveillance cameras were reasonable, they became unreasonable as soon as the store decided to zoom in on his naked buttock.
I get the impression he's going to say naked buttocks a lot today. Mr. Risberg.
Your Honor, Surely the use of hidden cameras is not unreasonable when the employees were told that they may be under camera surveillance while at any time on duty. And furthermore, plaintiff is simply wrong to characterize the locker room as a place where he had a reasonable expectation of privacy. The locker room was subject to a steady flow of traffic, both from security personnel and supervisors.
Cool. Trick here, yeah. And see how well your argument's going to go. That dog wasn't a bad dog, the one that ate the woman's ear and then vomited it and then ate it again. So this is apply the controlling rule to the facts of your case. When you first do this, keep it short and simple for your initial argument. Focus on the nut issue. What's your best argument? And that's what Sam did, and that is what Michael just did. Okay. Next thing we're going to do is we've applied the controlling rule to the facts of our case. Now, tell the judge about that great analogous case that you had.
Your Honor, there's an 8th Circuit case that applied Missouri law called Doe versus Guard Services. Now, in this case, a group of fashion models sued a security company that had put secret cameras in the ceiling. Now, the security company tried to argue that because none of the models completely undressed, it didn't violate the right of privacy. The court rejected that, though, saying it doesn't matter what the defendant actually saw. What matters is the plaintiff's expectation of privacy.
Michael, before you go, Sam, do you have additional analogous cases in your brief?
Yes, I do.
He may have 2, 3, 4, 5. He picked his strongest one for his initial argument. And we recommend that when you're arguing in oral argument as well. Take your best case. Don't say, well, I'm going to build up to it. I'm going to start with a weak one, and then I'm going to go, and then my third one, I'm going to knock him out of the park. There's a good chance judges go, okay, that was your best case. Thank you, counselor. Go sit down. Can we get you some water? Mr. Risberg, I don't think you need to argue at this point. So use your best case. Pull your best one out. You may only get to argue that one, depending on how much time the judge has to hear your argument. Mr. Risberg, do you have a case on your side of this?
Yes, I do. Your Honor, this case is very similar to a Michigan Court of Appeals case called Johnson v. Smith, which did apply Missouri law. In that case, a clothing store installed hidden cameras in a dressing room. Now, security personnel called the police when they saw that one of the patrons in the dressing room had a gun strapped to his leg. Now, while it turned out that this person was an undercover police officer and had a right to carry the gun, the court held that he could not succeed on his invasion of privacy claim because there were warnings posted within the locker room that anyone in it may be subject to surveillance while at any time. Therefore, in a situation like this, where warnings are posted, the plaintiff does not have a reasonable expectation of privacy.
Yeah, Michael, there were warnings posted in the shower in this case. I'm telling you what the law is.
I'm trying to speak.
All right. Stop. Go ahead. If you will see on our miscellaneous points number 1, 2, 3, direct all comments and argument to the judge and not to your opponent. This was a demo. They actually get along relatively well. Okay, group hug, ADR school after all. Direct all comments and argument to the judge and not to your opponent. Now, for your oral arguments that you'll be doing with your TAs this week, you check your Twin site. They're starting to get the sign-ups up. You won't have an opponent. It'll just be your TA and yourself. So you won't have an, although that would be interesting. If this happens with you and your schizophrenic other alter ego self, call me. If that happens, I would like to watch the little fight that you have. All right. Tell the judge about that great analogous case. Excuse me. Before I move on, we know that most of us are, well, one writing paradigm is crack analysis. C-R-A-A-C, where if we're going to do an analogous case or a rule proof, some of you are using different language, but we start with the rule and then we have a paragraph on an analogous case to help us understand the rule. And then we have the application. And then we have the application. Well, the question here is, we're going to move on here in a second to, well, should you, in your oral argument, should you do the same way? Should you give the rule, and then an analogous case, and then the application? Or should you give the rule, and then immediately apply the rule to your facts? For example, Michael points out that, Judge, just like in the Doe case, all the employees were told they could be under surveillance at any point in time while they're on the premises. So he's using the facts of the case right now to explain what happened. General rule in oral argument, I think, is generally you'll do the rule and then go to application, rather than do the rule, then analogous case, and then application. But there's no right and there's no wrong. Either way works, but a lot of times you'll swap those two. You'll give your rules and then do analogous case, or rules and application. Both are okay as long as we get both application and analogous cases in there at the same time, or soon. All right, once we've done this, it's time to wrap it up. You got to tell the judge exactly what you want the judge to do. Not, Your Honor, we'd like relief. What do you want?
The defendant asks that the court deny the plaintiff's motion for summary judgment. Opposite of that.
Do a Borat. Do a Borat. Come on, Bo. Come on. Inappropriate. Inappropriate. Yeah, he did it. So you went the wrong way, didn't you? Yeah.
I should go the other way then.
Or no, or just say, I concur. I concur. Mr. Risberg.
Well, the plaintiff asked the court to deny defendant's summary judgment motion on all counts.
Cool. Excellent. I'll let you guys sit down and we'll round of applause for Let's rock and roll through the rest of this handout. Excuse me. Legal logic is legal logic. That's the main point of this presentation on doing an oral argument. In a memo, we do crack analysis, or a version thereof. IRAC, ICRAC, CREAC, CRAC. But legal logic is legal logic. In a motion, legal logic is legal logic. Crack analysis, CREAC, IRAC, it's all the same. Oral argument, same way. You set up your argument the same way. The judge is expecting to hear the argument in a particular order. Give the judge what the judge is expecting. Keep your argument as short and direct as possible. The judge has your brief. It's a lengthy brief. It's a detailed brief. It has all the cases that you want the judge to know about. You don't need to cover everything. What? But I'm worried. What if I cover X, but the judge really wants to know more about Y? Don't worry about it. That problem is self-correcting. It's self-correcting. If you tell the judge, Judge, let me tell you in this particular case, we had two arguments. One is, you shouldn't have had those cameras in the locker room in the first place. Second legal issue was, once you took that picture, you shouldn't have put it up on an employee bulletin board. Two separate arguments. So you start talking about the obscenity of putting a camera, hidden camera in a locker room where folks are taking showers. And the judge, if the judge isn't interested in that, the judge goes, appreciate it, counsel. I'm more concerned about that photograph. How many people actually did see that photograph? It wasn't in a public restroom. It was in the employee bulletin room. And how many people actually ever look at what gets posted on an employee bulletin board? Well, we saw our photograph, 2 foot by 2 foot, naked buttocks. He's probably got a good argument for this, but you see how that's self-correcting. So come with what you think is your best argument. If the judge didn't want to talk about that, the judge will move you to where the judge wants you. Okay, consider conversing the rules. We've talked about that. Direct all comments to the judge, not to your opponent. We've talked about that. Shut up and listen. Shut up and listen when the judge speaks. You would be surprised how often in the real world during oral argument, the attorney is on a roll. And the judge then says, Counselor, I'm a little concerned about, and the attorney continues to speak. That's stupid. That's just dumb. You've got the decision maker who is telling you the decision maker has a question. Don't we want to answer the question that the decision maker is interested in? He doesn't understand. I'm going to continue with my speech to the end. No, but first of all, you're not. They have bailiffs and with guns and stuff. You're not. A friend of mine argued in front of the Second Circuit. He was clerking for the Second Circuit Court of Appeals in New York, and tax attorneys were there in mid-appeal and talking about such a case, and one of the judges interrupted and said, Counselor, have we already decided these facts in this other case? And the attorney looked at the judge and said, Judge, it's my understanding that I have 20 minutes to give my presentation. I will answer questions at the end. The judges looked among themselves and said, Counselor, thank you, that'll be all. Probably not a good idea, but it's not just that it's a courtesy that you owe the judge. This is a golden opportunity. Why are you arguing about how many people saw that photograph when the judge is concerned about how can we justify putting a camera in a locker? Why are you arguing about one thing when the judge wants to know something else? So listen, and when the judge opens his or her mouth, stop talking. Listen and answer that question. Do not read your argument. Do not read your argument. And you're going to have a tendency to want to do that. I've been working on it for a week. It's beautiful. But then email it to the judge and stay home. Okay? Oh, that's called your brief, isn't it? I mean, isn't that the brief that you file? Okay? Don't do that. You do not persuade people when you read them a speech. You just don't. Let's think back to high school. And all your buddies we're going to the lake. No parents. Sweet. We're sophomores, so it's not like we're kids anymore, okay? So we ought to better get mom and dad to let us go for that. Mother. There are 3 reasons why I should be allowed to go. Huh? That's not how you persuade someone to let you go to the lake. I don't know how you let them. You got to go to the lake as a sophomore. Then you mentioned that one of the guys is a senior, so you got good supervision. I don't know how you get to do that, but you don't read an argument. I don't say that you're not allowed to bring notes. Of course you should bring notes with you. But talk to mom. And talking to you, forget what you had. I know I had 5 reasons why I should be allowed to go on this thing. I've given my first 4 and then I've forgotten them. Oh yeah, and remember last year you said, as long as I showed myself to be responsible by getting nothing but B's and A's, you would give me more responsibility. Remember? So that was number 5. It was on my list. Don't read your argument, but you can refer to notes. Proper attire. Oh, radial's pretty good. Come fully prepared. Radials, come on, radials! Radials, proper attire. Radials. What is, okay, mud and stove. Radials. Knobby, oversized. Proper, it's hopeless. I know 2E isn't here. They'd be laughing up a storm right now. Okay. Proper attire. Real world, you got to dress like an attorney. Many of us don't own attorney stuff. So wear whatever you want when you're talking before your TA, unless your TA or prof tells you otherwise. Come fully prepared. What do I mean by that? If nothing else, you got to know your facts, your rules, and your best cases. And you worry about that. I don't know the facts. Yes, you do. I guarantee you, well, I don't know them perfectly. I don't care. The judge doesn't know them perfectly either. If you were at Harpo's tonight and somebody said, tell me about this libel case that you're working on. Cool. Well, there was this law firm and this one gal didn't like this other gal. She wrote a book. Well, what was in the book? Well, they said some mean stuff about vampires and stuff. I'm making that up. Really? Vampires? Okay. I don't know what yours is about. I know about the little kid selling eggs. I know about that one. You know the facts well enough. But know the facts. Know the rules. What is the rule on when you can sue someone for libel? What is the rule for when violation of an ordinance will impose liability? And best cases. If nothing else, your best case, if you have more than one issue, at least know a good case on one issue and a good case on the other. You should be in great shape if you do that. Materials you ought to bring with you. I'd bring a copy of your brief, your trial brief, in case you get a specific question from the court, where the court goes, well, what jurisdiction was the Doe case? What was it, the Doe case? Columbia, okay. It was a South American case out of Columbia. He really went a long way to come up with that case as an analogy. Does the country of Columbia follow the same restatement rules that we do? Okay, very good. He didn't know. He said, well, I think it's Missouri. And he looks and he says, oh, it's 8th Circuit. Okay. So you probably would already know 8th Circuit, but at least you've got your brief in case you have to answer a question. All right. Bottom line, have fun with this. This is real stuff. You're going to be doing this as a real attorney one of these days. Folks, one more thing about our TAs. They volunteered to do this because they know there's 2 ways to go through law school. And same way with this oral argument on trial, on arguing these trial motions. 2 ways to go through law school. Head down. Kick a dirt clod. The other one is chin up, looking around, saying, hey, I get a chance to argue in front of 150 people without a tooth? Me! I want to do that. So when you argue in front of your TA, have fun with it. Have fun with it. Wear a dog costume. I don't know what you're doing. Do something. Get out of it. Go.